We appreciate the opportunity to present here. What's the next phase for your company? Is there a Series A financing round or a possible sale of your company in the near future or in your horizon? Is that 1 or 2 years out or 3 years out? And importantly, what can you do today? My name is Jim Pinto. I'm an intellectual property lawyer with 28 years of experience, and I work with Vescent Photonics. And I want to address those issues with you today briefly in the time we have together. By way of background, Vescent is a Colorado company located just outside of Denver with about 37 employees. Vescent designs and manufactures laser systems and laser solutions for quantum. Vescent produces environmentally rugged laser products that can be used and deployed by our customers in the field. Vescent's products include items such as optical frequency combs, lasers, photonic devices, and control electronics. Vescent's products support and enable the entire Quantum 2.0 ecosystem, including quantum computing devices, quantum networking devices, quantum sensing, and quantum timing. So in terms of your next phase, a typical transaction in terms of a round of investment, if it's your Series A or possible sale of your company, is first the negotiation of what's known as a letter of intent or LOI, where the parties agree on the major deal terms and kind of the next steps and the rubric for the deal. That's followed up by an agreement and a diligence period, which can be 35, 45 or more days. And during the diligence period, the agreement is further revised and disclosures are made, and a definitive agreement is put in place, and then the deal closes. So there are certain things you can do now to prepare for that phase, because during the diligence period, the investor or the buyer is going to look into pretty much all aspects of your business, including the legal side. The buyer or investor is going to look into all of your corporate issues, your formation, your structure, your ownership, all contracts that your company has entered into, material contracts, important contracts that are the company has signed throughout the history of the company, your employees and HR issues, any kind of litigation or dispute related issues. Real estate issues, including your leases or if you own real estate, your financials, including your accounts receivable, accounts payable, and then your intellectual property. They'll also look into other areas like your tax filings, environmental issues, things of that nature. They're really going to turn over every rock, particularly if it's the sale of your company. On the IP diligence front, and this is where I want to spend most of my time here in the remaining minute and a half, to talk about the things they look at in terms of IP. They'll look at your trademark portfolio, your patents, your trade secrets, the important ones, your software. Who owns your software? Who developed your software? Do you use open source software within your code, which most companies these days do? Do you have assignments from every person or entity that touched your intellectual property or contributed to your intellectual property, including contractors? Your non-disclosure agreements, your suppliers or vendors, whether you have tech licenses in or out of your company, your agreements with customers, if you've done any custom development for customers, if you've done any government contracts like SBIRs or others, if you developed any of the IP using university research or university resources, and then they'll also look at intellectual property infringement risks. So to prepare for that next phase, you can take steps now. Some suggestions on this front. First of all, be aware of every agreement your company signs. This may seem onerous, but you need to look at them and preferably have outside counsel or experienced lawyer look at the agreements, because they can include provisions in there that may not be favorable, that you may need to negotiate. Also, be cautious about disclosing your critical trade secrets without some form of non-disclosure agreement or confidentiality provision in place. If you have contractors or developers assisting with your IP development, make sure that they assign their intellectual property contributions back to your company so that your company controls that intellectual property. And then manage other legal risks like third-party patent infringement risks or other types of legal risks that will make the transaction smoother. If you have any other questions now or in the future, I'm certainly happy to help. Thank you so much.